Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. So today I will tell you about what should a seafarer consider before hiring a maritime lawyer. Okay, in the age of globalization, cruise ship companies seem to have almost unlimited leverage when it comes to setting the term for employment wages and working conditions. Fortunately, seafarers are not always at the mercy of their employers. As long as they are aware of their right and what they can do to seek the redress they deserve. Many crew members are not aware of their full right and protections, and as a result can be taken advantage of without them even realizing it before it is too late. To help remedy this situation, attorney Elias Pirutnikas provides free legal advice to all crew members. Before hiring a lawyer, it is best to sort out what kind of legal problem you have first. This will determine which country the lawyer should be licensed in and what legal field of expertise he or she must have experience in. For example, a seafarer who is charged with a crime and needs to dedicated defense would need a crime lawyer that is licensed to practice in the country where the charges were brought up. Seafarer can write to attorney Elias Pirutnika should they need clarity on the type of legal issue they have and what kind of lawyer they should hire. Once the decision to hire a maritime lawyer is made, the claimant must act quickly since there is usually a time limit for filing a case. In addition, the lawyer should explain the following. The first, what option you have for solving your problem, and then the second, what are your chances of winning or getting a settlement, and then the third, how long your case will take, and then the fourth, if you have to pay, should you lose the case and how much? And then the sixth, what kind of payment arrangement he or she will accept. And then who is a seaman or crew member under the Jones Act? Unlike land workers, maritime workers cannot claim workers' compensation benefits. Instead, an injured maritime worker or crew member must file a claim for damages under the Jones Act. The Jones Act gives a maritime worker, more specifically a seaman or crew member, the right to claim damages against this employer in the event of injury caused by the employer's negligence or a ship owner's failure to answer the seaworthiness of a vessel. Under the Jones Act, the plaintiff can claim loss of income, medical expenses, and money compensation due to an injury suffered aboard a vessel in the course of performing his duties, or while in the service of the ship. However, the Jones Act only protects maritime workers that meet the legal definition of seaman or crew member. The Jones Act doesn't define the status of a seaman or crew member. Rather, case law has sought to clarify the legal definition of a seaman or crew member. In two cases, Harbour Duck and Barge Company v. Papai in 1997 and in Chandris v. Latsis 1995, the U.S. Supreme Court stated that to be classified as a seaman or crew member and be covered by the Jones Act, the plaintiff must meet the essential requirements. His duties must contribute to the function of the vessel or to the accomplishment of its mission. He must have a connection to a vessel in navigation or to an identifiable group of such vessels. There is substantial in terms of both its duration and its nature. The first requirement is fairly self-explanatory. Every vessel that takes to the water does so with a mission, whether recreational, scientific, or commercial. The mission might be to transport passengers from one port to another, or it may be to transport cargo. Every seaman constantly aboard the vessel contributes to the fulfillment of the vessel's mission. That is, everyone working aboard a vessel is contributing in some way to a vessel's mission, or they would not be aboard. The cook, the waiter, the cleaner, the navigator, the ship's doctor, the engineer are all contributing in their own way to fulfillment of the vessel's mission. It is with the second requirement that things start looking a little tricky, and this is why it's important that in the event of an injury that you contact a maritime lawyer. This is because while you might meet the fire requirement, this is because while you might meet the first requirement, you may not necessarily meet the second requirement. And if you don't, you may not qualify to file a claim under the Jones Act. The second requirement for defining a seaman or crew member has two parts. The plaintiff must work on a vessel in navigation, and his contribution or work is substantial in terms of both its duration and its nature. To qualify as a seaman or crew member, a maritime worker must work most of this time on a vessel that is in navigation, and it is the in navigation bit that is important. For a vessel to meet this definition on it must meet the following criteria. The first, the vessel must operate on navigable waters, which are waters that the vessel can travel across to reach the United States or another state within the Union. Navigable waters could be an ocean or a large river or an inland lake. And then the second, the vessel must be capable of moving under its own power. And then the third, the vessel must not be permanently anchored to the sea floor. This strict definition excludes oil rigs. It also excludes vessels sitting in shipbreaking yard. While an oil rig appears to float, it can only move if it is towed. For most of the time, an oil rig is anchored to the seafloor and so doesn't meet the definition of a vessel in navigation. When it comes to assessing the worker's contribution to the operation of a particular vessel or a fleet of related vessels, a seaman or crew member is one who contributes at least 30% of his time aboard in the fulfillment of the vessel mission. Consider this example. An administrative clerk who normally works in an office online but occasionally catches rides on ships to and from port suffers an injury while aboard. Is he entitled to file a Jones Act claims? Well, it depends. If he performed no work aboard the ship that contributes to the operation of the vessel, then no, he doesn't qualify as a seaman or crew member under the Jones Act. If this administrative clerk spent 40% of his time aboard a ship performing duties that contributed to the operation of the vessel and the balance of his work time in office on land, then he could potentially qualify as a seaman or crew member because more than 30% of his work time is given over to duties aboard a vessel in navigation. A court would look at a plaintiff's career with the shipping company. If he spent more than 30% of his career aboard a particular vessel or fleet of vessels, he could qualify as a seaman and seek damages under the Jones Act. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe the channel. See you in the next video, and bye bye.